Cover. Yes,
May I pay for listing of a criminal revision petition on 14?
14.
Right.
In prayer is later of the premises number 895 of 2023 for admission on 17/5. Obliged office.
May I please your lordship, I would like to mention for listing of a high-end criminal appeal on 16th lodge. Highly operations.
We have paid full lordship, seeking adjournment regarding item number 19.
Item number
19.
19.
Yes.
On the pair being made by Mr.
Kajaki Aklas.
Learned Counsel for the petitioner, Justice shall list the matter on. You go for the petitioner?
Yes. Opposite party
When?
after 2 weeks, my lord.
When?
After 2 weeks.
Did you inform the other side?
Yes, my
No.
Oh.
The private party is there.
Yes.
State we have no objection, but
Yes.
private party.
I
is
will
there.
communicate.
No, you first communicate, only then we will
communicate.
consider. We will call the matter.
Yes.
For listing of a criminal revision petition
When?
on 17th. Deeply obliged.
Please your lordship, like to mention item number 26, CD not received.
Yes.
Lordship behind the bar for 38 days. Sees a lady suffering from ailment, a short date may be given.
Okay. Go away when?
There's 4. 2020.
20. Mr. B.B. Gogoi, learned additional PP submits that he has not received the case diary. Accordingly, it is provided that Mr. Gogoi shall produce the case diary before this court on 20. Mr. Your good name?
A mena.
Learned Counsel for the petitioner present.
Obliged.
I will mention item number 46, my lord. This is when we come out of news.
6 orders.
Second concept from
46.
46, my lord.
When to be listed?
My lord.
When?
After 3 weeks, my lord. Again,
After?
3 weeks.
Mr. A.K. Azhar, learned counsel for the petitioner, press for listing the matter after 3 weeks. Fair allowed.
Obliged. May I please your lordship, listing of criminal petition lordship.
When?
Supposed to be listed lordship this week, but it not listed. Can it be on Monday lordship?
Monday, not possible.
That third, that's Tuesday lordship. 14th. Obliged.
May I please? I make to mention for listing one criminal revision petition madam, on 14 May.
Okay.
Obliged.
May I please your lordship, I beg to mention for listing of a bail application, it was supposed to be listed on today, your lordship. Kindly
When do you want?
16th, your lordship.
16. Okay.
Lordship, matter may be listed on 17th May regarding criminal revision petition. Authorized.
My lord, this was directed to be listed, my lord, 2 weeks back, my lord. It's not being listed, my lord. May I pray, my lord, any date in the next week, my lord?
Take a date from him.
From 2020. 20 will be, my lord,
Monday.
16 might be, my lord,
Take a date from
Yes.
him. As per your convenience.
To mention for listing as criminal appeal.
When?
Hearing.
hearing matter.
Hearing will be in due course. Why?
Lordship, it was coming in the daily list, Lordship. And it was listed on 13 last, but it not reached, Lordship.
13.
13 Lordship.
When do you want?
16 Feb, Lordship. Much obliged.
May I please your lordship, I beg to mention item number 34 and 35. Apparently, this matter may taken up
Diary not received.
after 1 week, my lord.
Mr. B.B. Gogoi, learned additional PP submits that he has not received the case and press for granting him some more time. Here is accordingly allowed. Justice shall list the matter of
Interim is there, madam, 3030.
30. Till then, interim order passed in both the cases shall continue. Your good name?
J. Ali, my lord.
Mr. Zayali, learned counsel for the applicant present. For the applicants.
Obliged.
Hey, please, your lord, I beg to mention that item number 14, my lord,
Item number
14. Item number withdraw this matter, my lord.
14.
Yes, my lord. Withdraw this matter, with liberty.
What is your name?
Be das.
Ms. So-and-so learned counsel for the applicant submits that she has the instruction to withdraw this application. And accordingly pays for granting her permission to withdraw the same. There is accordingly allowed. However, liberty will remain with her to approach the court again by filing a appropriate petition with the applicant. Okay.
Please also. But
But, it is just disposal of withdrawal. Is the CD available here?
No,
Or
so this
motion
is for
call?
motion,
Okay,
madam, today.
okay.
May it please also. So I beg to mention item number 45 also. So in this, I kindly allow us to withdraw this matter also.
Withdraw.
45.
45 also.
Yes.
Your good name, please?
Jai Hati Moria.
Mr. J. Hatemuria, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition and accordingly pays for grant him permission to withdraw the same. There is accordingly allowed. This transfer petition stands disposed of on withdrawal.
May I please, your lordship? Item number 39 and 40, lordship. CD was called for, but CD is not there.
Yes. 39, 40. 39. 39.
Gogoi CD not available.
It did not receive, madam. Shut
Mr.
down.
David Gogoi, learned additional PP submits that he has not received the case ID and pays for granting him some more time. There is accordingly allowed. Recess list the matter on
21st.
21st.
Sir, interim.
Till then, in both the cases,
Interim assignment.
till then interim order passed earlier shall continue.
On 30.
Mr. S. Rana,
Yes,
learned
31st.
counsel for the applicant.
Your lordship, I beg to mention item number 48. Your lordship, my senior counsel is out of station. I'm seeking adjournment today, with the consent of opposite party.
What is your name?
D. Deca. Your lordship, I'm praying that, till the next date interim order may be continued.
You are appearing on behalf of
I sing.
Ms. So-and-so, learned counsel appearing on behalf of Mr. I Singh, learned counsel for the petitioner. With consent from the other side, press for listing the matter when?
After 2 weeks,
After 2 weeks. There is accordingly allowed. Recess shall list the matter after 2 weeks. Interim order passed earlier shall continue.
On 31st.
My please, your lordship. Lordship, I beg to mention for listing of a criminal revision petition,
When?
maybe on 16th May.
Okay.
Lordship, I had filed an anticipatory bail application on last Saturday, your lordship. It has not come up yet and it is not there in Monday's list also. Can it be taken up on Monday, your lordship?
Monday, we have lot of matters. Tuesday,
Most of it. May it please, your lordship, I beg to mention item number 26. My pardon, lordship, it's 27.
item number
27. 27.
Diary not.
27.
Lordship, my agenda matter for the day. It may be continued.
Mr. B.B. Gogoi, learned additional PP submits that he has not received the case diary and price for granting him some more time. There is allowed. Places the list the matter on
30.
33, 13.
30.
30.
30. Interim is there.
Till then interim order passed earlier shall continue. Mr. Your good name?
P. Fukan.
Mr. P. Fukan, learned counsel for the applicant present.
May I please, lordship? I beg to mention item number 52 of supply list. Madam, I kindly pass over for today, lordship.
On the pair being made by Mr. Z.
US
Singh.
Borgohain.
Your Z Singh,
US Borgohain.
Mr. U.S. Bargumai, learned counsel for the applicant. The case is then adjourned to be listed on when?
Next week, lordship.
Next
Friday.
week.
On 22nd, May. Okay.
May I please, your lordship, I beg to mention one criminal petition for listing, lordship,
When?
on Monday. Lordship.
Monday, not possible.
Not
Tuesday.
during next.
Tuesday, lordship.
Tuesday, okay.
Wait, this is your lordship. Lordship, I beg to mention item 37, lordship, seat is not less than the matter can be adjourned.
37,
37.
diary not received.
Mr. B.B. Gogoi learned additional PP submits that he has not received a KZ. Accordingly, it is provided that Mr. Gogoi shall produce the KZ before this court on
31st, interim is there.
Lordship, interim.
till then interim order pass earlier shall continue. Miss, your good name?
AK Choppy, lordship, appearing on behalf of.
AK,
AK Choppy,
learned counsel for the applicant present.
like.
Item for withdrawal. Item number 50.
Lordship, may I please your lordship, lordship, petitioner does not want to press this matter anymore, lordship, kindly matter may be withdrawn.
Your good name?
J Ghosh,
Ms. Jay Ghose, learned counsel appearing on behalf of
R Mutunda.
Mr. R. Mazumdar, learned counsel for the accused submits that she has instruction to withdraw this application. And accordingly placed for granting her permission. Here is accordingly allowed this BA since dispose of on withdrawal.
Oblige, lordship.
For motion bail application, item number 1.
Yeah, please, the lordship for 39 application, lordship. FIR phase 7, lordship. Lordship, the petitioner is the lordship delivery boy, lordship. May I read, lordship, FIR? So with due respect, I beg to state that I am an employee of the Instancer Service Private Limited, Patharpuri, under your honor's jurisdiction. One Rupamdas so has been working as delivery boy at our company, lordship. On so he took some parcels from the office to deliver the same to customers, but instead of delivery to customers, he possessed the same for his personal uses. Lordship. This is the case, lordship. Lordship, today, lordship, 15 days, lordship, behind the bar, lordship. Only allegations got lordship, seized article already recovered, lordship. Today, lordship, 15 days, lordship, behind the bar, lordship.
Yes, Gogoi?
Your lordship, forwarding, that is my lord, page 12,
Recovered,
recovered some goods, my lord, from his possession.
yes.
Ground number 2 and 3, my lord.
Reasons of arrest, lordship. Point number 2, lordship. Stolen items has been recovered from his possession.
So, whether further custodial detention is required if the articles have already been recovered?
Article recovered, that is.
Heard Mr.
And Alama.
Learned counsel for the accused and also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. In this petition under section 439 CRPC, this petition under section 439 CRPC is referred by accused Rupam Das, who has been languishing in jail as in connection with non-mati PS case number 91 of 2024 under section 381 IPC. It is to be noted here that above the case has been registered on the basis of one FIR lodged by one. What is the name of the complainant?
Name of the complainant, lordship, Devendra Thapa, senior executive of operation.
Devendra.
Yes, lordship.
Devendra Thapa on 24/4/20. 24/4/2024 2024. The sense of allegation made in the FIR dated so and so is that. When Rupam Das was working as delivery boy in their company, in the name and style, Instruser Services Private Limited, situated at Patrokore. The sense of allegation made in the FIR dated so and so is that on 23rd 4, 2024, he took some parcels from the office to deliver the same to the customers. But instead of delivering the same to the customers, he possessed the same for his personal use. And having checked his house, some stolen articles were recovered, namely Poco M6 Pro 5G, one piece, JBH Commercial 3SSM 100, Audio Array MT5 one piece, Logitech Bluetooth mouse one piece, Logitech keyboard one piece, RAM board one piece, motherboard one piece, etc. The learned counsel for the applicant submits that the learned counsel for the accused submits that the accused was arrested on when he was arrested
26 crores.
on 26/4/2024, and since then he has been releasing in jail as well for last 15 days. And that the stolen articles have already been recovered from his possession, and as such, his further custodial detention may not be required, and therefore it is contended to allow the petition. On the other hand, Mr. B.B. Gogoi, learned additional PP, referring to the seizure list and also the forwarding report, submits that the stolen articles have already been recovered. But having heard the submission of learned advocates outside, I have gone through the petition in the documents placed on record, and it appears that the accused was arrested on 26/4/2024. And since then, he has been languishing in jail as well for last 15 days. Further, it appears that the stolen articles have already been recovered and seized from his position. Since the stolen articles have already been recovered, and the accused is also languishing in jail as well for last 15 days, his further custodial detention seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one security of like amount to the satisfaction of the CJM camera pipe, the accused being burdened.
Number 2.
DPO, please.
It is your lordship. This revision is directed against an order rejecting a prayer for Jimma. Now, my lord, the petitioner, your lordship, my lord, he is a businessman from Mirzapur, Uttar Pradesh. He came to Tinsukia in connection with some business, and he was carrying with him rupees 20 lakhs. And my lord, while the business transaction did not materialize, he was going back by train. At Bangangaon railway station, he was detained, and that money was found with him along with other papers. Then, my lord, he was arrested and he was there in custody for 7 days. He has been granted bail eventually. But the application for custody of the amount has been, my lord, rejected. And, my lord, the petitioner has explained that, my lord, that this money he was carrying proposing to sell a property. If your lordship kindly comes to page 31, that's the agreement for sale, from where, my lord, he got 18 lakhs rupees. And, my lord, with that, he came for business purpose to Tinsukia, which didn't materialize, and he was going back with that money. So, my lord, page 31 is
Where is the seizure list?
my lord.
Where is the seizure list?
Seizure list. he is not there, but the order, my lord, reflects it. If your lordship comes to page 30, page 30 is the first order passed by the magistrate. Case record is put up today on this, as your lordship come to page 30, my lord.
Yes.
Case record is put up today on strength of Jimma petition bearing number such and such filed by Jimma petitioner accused Ajay Agarwal for Jimma of the seized currencies amounting to rupees 20 lakhs. I have seen the Jimma petition being number so and so, and also heard the learned counsel appearing on behalf of the said Jimma petition. Learned counsel submitted that the accused Jimma petitioner, who is a resident of Mirzapur, UP, had received rupees 18 lakhs as advance taken amount pursuant to an agreement for sale at dated 5/2/2024 in respect of his landed property at UP. Learned counsel submitted that the accused petitioner is the proprietor of one Messrs. Vindhya sanitary store situated at Mirzapur, UP, and is a regular taxpayer. Learned counsel submitted that the seized currencies amounting to rupees 20 lakhs is the hard-earned money of the accused Jimma petitioner. Learned counsel submitted that the accused Jimma petitioner had gone to Tinsukia, Assam for business purpose along with the cash of rupees 20 lakhs but could not succeed. Learned counsel submitted that as such, when the accused Jimma petitioner was returning to his native place by train, he was apprehended by the police on suspicion when he could not produce any appropriate documents. Learned counsel has accordingly submitted that the Jimma of the seized currencies may be handed over to the Jimma petitioner by imposing any conditions as deemed fit by the court. Later report, we accordingly call for from the IO concerning as to whether the seized currency of rupees 20 lakhs is required for further investigation or not. After verification of the agreement for sale dated 5/2/2024, executed by the accused Jimma petitioner as the seller along with the registration certificate issued in favor of Messrs. Vindhya sanitary store situated at Mirzapur, UP. And these documents are produced, my lord. The registration certificate your lordship will find at page 14.
Where is that report of the IO?
My lord.
Where is the report of the IO?
Report of the IO, my lord, there is no report, but it has been reflected in order dated, my lord, page 46, at page 46, by which it has been rejected. Accused Jimma petitioner is present today. Report has called for receipt. The said report reveals that the investigation of the case is going on to ascertain the source of the seized money, and as such, the seized money of amounting to rupees 20 lakhs is required for further investigation. Jimma petition bearing number so and so, there is so and so, accordingly stands rejected. And your lordship will see, my lord, the two documents they asked for that was produced, registration of the petitioner's farm at page 14. Then the, my lord, the agreement for sale that has been annexed, my lord, the translated copy I have shown your lordship. And the, my lord, he is a taxpayer, income tax returns, my lord, for the last 3 years, those are also my lord.
That's all right, but are you entitled to carry such a huge amount of case?
My lord, that is another aspect, but the fact remains that, my lord, he has got explanation as to how he was carrying this. Because many transactions in business, my lord, happen only in cash. And therefore, he was carrying this amount. And there is
There is bar imposed by the income tax department and some other departments also in respect of cash transaction.
that is true, my lord, but that is not the case against which, my lord, they say that this may be a stolen money. There has to be some complaint somewhere, my lord. And in any case, my lord, see this amount, my lord, lying in the treasury will be of no help, and my lord, he will be suffering because he will not be able to, my lord, use this money for his business. And he has got, my lord, proper explanation for carrying the money. Whether, my lord, the income tax department proceeds against him, that is another aspect. So far as Jimma is concerned, my lord, the court has to see whether, my lord, the money is required for further investigation or not. And, my lord, the two documents that were asked, my lord, that has been produced before the, my lord, magistrate.
Yes, Gogoi, what is your submission?
My lord, let me take a fresh instruction, my lord. Earlier they changed that for further investigation it is required. Now we do not know, my lord. Let me take instruction, my lord.
Written or verbal?
No, my lord, written.
Written.
There is nothing to improve on this, my lord. At least those documents are here before your lordship. Before the trial court also it was there, my lord. The agreement.
No, one aspect has to be considered whether investigation in respect of the money is completed or not.
Yes.
My lord,
If it is completed, then there is no purpose for keeping the matter, keeping the cases, case in the treasury.
my lord, my
Definitely will
submission to
consider-
your lordship, my lord, your lordship may impose condition that I'll leave the, my lord, bond to that amount, my lord, or any.
We'll say, let the report come if investigation is completed. Heard Mr. M.K. Soduri, learned senior counsel, assisted by Mr.
T.N. Srinivasan,
T.N.,
Srinivasan.
learned counsel for the petitioner. And also heard Mr. B.B. Gogoi, learned additional speaking for the state respondent. Correctness or otherwise of the order dated 22/3/2024, passed by the learned judicial magistrate first class Bongaigaon in JRPS case number 17 of 2024 is challenged in this petition under section 397, read section 401 and 482 of the Code of Criminal Procedure. It is to be noted here that by the impugn order dated so and so, the learned court below has dismissed the petition filed by the petitioner seeking custody of rupees 20 lakhs, which was seized from him on when it was seized.
It was seized on, my lord,
20th February. 20th February.
20th February, my lord,
28th February
20, my lord.
2024. 2024. Having heard the submission of learned advocates of both the parties, it is provided that Mr. B.B. Gogoi, learned additional PP cells, produce a written report from the IO concerned as to whether investigation in respect of the seized case, the seized sum of rupees 20 lakhs has been completed or not. Fixing the matter on
To 22nd? 22nd, yes.
22nd. Sorted
20.
20.
Item number 3.
My lord, this is a revision petition against the impugn order dated 4/3/2024. The background of the case is, my lord, the petitioner is doing his job at Bengaluru. Unfortunately, on 17/2/2022, my lord, 23,
Where is that impugn order?
impugn order is page 31.
Rupees was lent, only 5 lakh rupees were lent. However, there were 3 check bounce cases for 5 lakh rupees each, and 3 were tried separately, Your Lordship. And under such circumstances, in 3 of the cases, there was judgments were passed whereby imprisonment of 6 months and a fine of 7,50,000 was passed in 3 of the cases individually against the petitioner, Your Lordship. Lordship, I would like to refer to the judgment of Damodar S. Prabhu, Your Lordship. In
No, at this instance, we will not consider the merit of the case.
Lordship,
Let notice go.
notice will have.
Let the record come. We will hear you.
Yes,
Copy it as a NI case. NI Act. Heard, Mr.
BJM.
Learned counsel for the petitioner and Mr. B.B. Gogoi, learned additional PP for the state respondent number 2. In this revision petition, under section 397, read section 401 of the Code of Criminal Procedure, the petitioner namely Gopeshwar Das, has put to challenge the correctness or otherwise of the judgment and order dated 22/9/2023 passed in NI, share case number 1 of 2022. Passed by the learned additional Chief Judicial Magistrate Sirang, Kajalgaon. It is to be no, and also the judgment and order dated 12/1/2024 passed in criminal appeal number 08 of 2023. Passed by the learned Sessions Judge Sirang, Kajalgaon. It is to be noted here that by the impugned order dated 22/9/2023, impugned judgment and order dated in NICR case number 01 of 2022, the learned additional Chief Judicial Magistrate Sirang has convicted the petitioner under section 138 NI Act and sentenced him to suffer SI for a period of 6 months and also to pay a fine of rupees 7,50,000 with default stipulation. Is there any default stipulation?
Yes, Your Lordship.
And by the impugned judgment and order dated 12/1/2024, the learned session judge in criminal appeal number 08 of 2023 has affirmed the conviction and sentence of the petitioner, so handed down by the learned additional Chief Judicial Magistrate Sirang in judgment and order dated 22/9/2023 in NICR case number 01 of 2022. Peruse the petition and the documents placed on record and also peruse the impugned judgments. Let notice be issued to the respondents returnable in 4 weeks. Step upon respondent number 1 be taken by registered post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 2 since Mr. B.B. Gogoi, learned additional PP, appears and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Rest shall call for the call for the record from the learned court below. The petitioner shall deposit a sum of rupees, no, deposit 20% of the fine amount before the registry of this court within a period of 1 month from today. As per provision of section 148 of the NI Act. List the matter after 4 weeks. Same order in the next petition also.
Case number certificate. Lordship, in the second also deposit because as I am relying on Damodar S. Prabhu, Your Lordship, in that case it is said that it is the bounden duty of the complainant to disclose whether there was another case pending out of the same transaction or not. It was not done by them, Your Lordship.
Okay, but here also you deposit the amount.
20% I am depositing overall, Your Lordship, because
In both the cases, because of both are separate cases.
Item number 6.
Of 438 application method. For the FIZ method, page 12 method. Hereby the informant method claim himself. as
Page
a
number?
12 method. The informant claimed himself as a directing guardian holder method of one method. Petitioner number 1 method, Santanu Sodori method. Pertaining to land method, tag number 10291527 method. And coming to know method, he submitted an application to stop the sale proceed method. With the wife of the method, petition number 2, that is Biswajit Sodori method. Number 2, whether method the informant is a writing guardian holder or not method. We made an application before the Deputy Commissioner Amin Gaon method. To know about the status of the informant method.
So you are not the owner of the land.
No, my lord, the Santanu Sodhuri, and his father is a owner of the land, my lord. I am so, my lord.
Acha,
Yes, sir.
acha. No, no, this,
Informant is not the owner, my
no,
lord.
no, the informant who lost the case, he is not the owner of the land.
He claimed he is a royalty Khatian holder, my lord. It is under, my lord, the Assam settlement tenancy rules.
So whether he has any right
No, my
over
lord.
the land.
No, my lord. Now, my lord, kindly see, we, the one of them, like, co-partner, my lord, made an application before the deputy commissioner to know the status, my lord, under RTI Act, my lord. What is the reply, my lord? Page 33, my lord.
Yes?
Page 35, my lord. Now, my lord, clause 2, my lord, kindly see, my lord. As per the handwritten note, no rioting, rioting Khatian and rioting Sita has been found in respect of the DAG number so and so of revenue village Rangmahal under Moja Silason revenue circle. After coming to know, my lord, we also, my lord, requested the deputy commissioner, page 19, my lord. My lord, come to my lord, page 90, my lord, it will clear the picture, my lord. Kindly see page 19, my lord.
19.
Yes, my lord. The my lord, prospective seller and the my lord, purchaser, my lord, made an application to the deputy commissioner to further inquiry, my lord. Whether, my lord, no objection certificate has been actually filed or not, my lord. And page 20, my lord, the sale permission was granted on 9/4/2014, my lord. Against, my lord, the Otono Sodori and Tantano Sodori, my lord, and the buyer, my lord, Banu Das Sodori, my lord, wife of, my lord, Biswajit Sodori, that is, my lord, executive petition number 2, my lord, page 20.
Okay.
Yes. Then page
Heard
20.
Mr. S. Borthakur, learned counsel for the petitioner, and also heard Mr. B. Sharma, learned additional PP for the status complaint. Apprehending arresting connection with Sanctuary PS case number 258 of 2023 under section 420, 468, 471, 34 APC. This application under section 433 services be heard by two applicants, namely Santanu Chaudhary and Biswajit Chaudhary for grant of previous pay. The above noted case has been registered on the basis of one FIR lodged by one
Lucky Prasad Sodori. Lucky Prasad Sodori.
Lakshmi Prasad Chaudhary on 1/8/2023. The sense of allegation made in the FIR dated so is that he is the Rayoti Khatian holder of Pattadar of late Nalini Chaudhary, Dambaru Chaudhary, Lakshadhar Chaudhary, and Puspadhar Chaudhary of a plot of land bearing DAG number 1029 and 1527. And Santanu Chaudhary, son of late Nalini Chaudhary, and Biswajit Chaudhary, trying to sell the aforesaid plot of land. by filing first affidavit. No, by filing an affidavit forcing his signature in the court of Sri Monmi Kalita, stating that some understanding has been arrived at between them. Thereafter, he filed an application to stop the sale proceeding. No, to stop the process of selling of the aforesaid plot of land. Mr. Borthakur, learned counsel for the applicant, referring to Annexure 7 at page number 35 of the petition, submits that the applicants submits that there is no record that the applicant, no record that the informant is a Rayoti Khatian holder of the plot of land bearing plot of land in respect of tag number 969 old 1029 new and 975 old and 1527 new of Revenue Place Rangmahal under Sila Senduri Mauza. Sila Senduri Gopa Mauza. And that the applicants have entered into an agreement with one
Page 22, madam, this LD was executed, madam, on 10/4/24, madam. Page 24, madam, kindly see, madam. It is executed by Autono Sodori and Chris petition number 1, madam, and wife of the madam, petition number 2, madam.
to Srimati Bhanudas Chaudhary.
Yes, madam, wife of madam, petition number 2, madam.
Bhanudas Chaudhary. And an agreement was also executed on 19/4/2024 and sale permission was also granted by the, where is that permission?
Page 20, madam,
20?
page 20, madam, Annexure 3, madam.
Sale permission was also granted by the Deputy Commissioner Kamrup on 9/4/2024. And that the applicants are innocent and they are no way involved with the offense alleged. And they are ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. Yes, Mr. Sharma.
My lord, at this stage, I pay for call for the CD, my lord.
The other than
To
Mr.
find out
Sharma,
the, my lord, what
learned
done
additional
by-
PP submits that at this stage only the case that may be called for. Having heard the submission of learned advocates of both sides, perusal of the case area is found to be necessary, and accordingly it is provided that Mr. Sharma shall produce the case area before this court on
31st May.
21st May. And in the interim, considering the submission of learned counsel for the petitioner, and also considering the documents placed on record, this court is inclined to extend interim protection to the applicants till receipt of the case area.
Right.
It is provided that in the event of arrest of the applicant in connection with case number so and so, they shall be released on PRS bail, interim PRS bail, under executing a bond of rupees 50,000 with one security of like amount to the satisfaction of the arresting authority. The above privileges are subject to the following three conditions. plus condition they shall not leave the jurisdiction of CJM Amingaon without prior permission.
Your Lordship. Lordship, this application has been filed on anticipation, Lordship. Your Lordship. Your Lordship.
No, till today, no case has been registered.
Yes, we could not locate whether any case has been. So my prayer at this stage, let the report be called whether there is any pendency of case.
Heard Ms. Tishom, learned counsel for the applicant. Then also heard Mr. B. Sharma, learned additional PP for the state respondent. Apprehending arrest in connection with any case pending in the any case registered with the All Women Police Station, Panbazar. It is application under section 438 service is prepared by applicant. Jyoti Prasad Kolita for grant of periods paid. Having heard the submission of learned advocates of both sides, it is provided that Mr. Sharma shall produce. No, Mr. Sharma shall obtain written instruction from the officer in search All Women Police Station as to whether any case has been registered against the present applicant or not on Tuesday.
Tuesday, my 14.
Obliged.
Items for admission, item number 19.
Your Lordship. The contracting counsel, Mr. J.I. Gaurav, Your Lordship. And he, last night, Lordship, he went to Delhi, some medical emergency, Lordship. Kindly, this matter may be accommodated after 1 o'clock.
You are for?
Petitioner, Lord. M.S. Mujumdar,
You are for petitioner.
Lordship.
Did you inform the other side, Mr. S. Ali?
Lordship, on the morning, Lordship, mention was
Made,
Lordship,
yes.
but he was not there, Lordship, and now also he is not there.
Who?
Mr. Respondent, counsel.
No, private respondents are there.
Lordship, then there is,
R3 and R4.
he is not there, Lord. He is not available, Lordship. I have searched him.
No, but you have to inform the that side. no?
Lordship, whether was the now Lordship called Lordship and he is not available, Lordship. Kindly, Lordship, inform us.
Heard Mr.
AMS Majum.
AMS Mozumdar, learned counsel for the petition. And also heard Mr. B. Sharma, learned additional PP for the state respondent. Number 1. None appears to the respondent number 3 on call. Mr. Mozumdar, learned counsel for the petitioner submits that conducting counsel Mr. J.I. Borgunya has left for Delhi due to medical emergency and therefore prays for listening the matter after
1 of them.
1 week. Prayer is accordingly allowed. Prayer is the matter after 1 week.
Item 20.
So far instruction is concerned, matter is already committed. So case number is different. One letter also in the case record is available. Let's see additional see them.
Cases?
Committed to the court of the session just concerned. So case number is already changed on for date why that record is not received by the registry.
Record not received.
No, not one.
Heard Mr.
K. Rahman.
Learned Counsel for the petitioner and Mr.
A. Mohammed.
A.
Mohammed.
Learned Counsel for the respondent number 2 and Mr. G. Sharma, learned additional PP for the state respondent number 1. Office note dated 8/5/2024 indicates that the case record has not been received from the learned court below. And in view of and the letter dated 22/4/2024 of the learned additional chief judicial magistrate Dorong Mangaldoi indicates that the case has already been that zero case number 895 of 2023 within bracket PRC case number 1227 of 2023 arising out of Dolgaon PS case number 204 of 2023 has already been committed to the Court of Learned Session Judge Mangaldoi on 26/9/2023. Accordingly, it is provided that registry shall call for the GR case number so and so arising out of Dolgaon PS case number so and so from the Court of Learned Session Judge Dorong Mangaldoi, fixing the matter on
29 May.
interim pair will be considered only after receiving the record from the learned court below.
Item 21.
May I please? Look, in this case, my lord, informant and my lord accused jointly prepared this my lord quashing petition. As the my lord matter is already my lord settled down in between the parties. My lord.
What are the sections?
Section 376 is there, my lord.
376.
Yes. my lord.
The
As
case
per
is surseated.
charge sheeted.
No, the question is, can the offense under section 376 IPC be quashed?
My lord. My lord, she is my lord, sworn before the my lord notary, my lord, it was consensual. Marriage was also my lord solemnized. So my lord, and so my
There
lord,
is a solemnized between.
between the parties, my lord. My lord, my lord, for the my lord, breach of marriage of my lord, they lost the my lord FIR before the police station. And ultimately, my lord, it is my lord consensual. My lord.
Maybe,
Yes.
but there is bar. One judgment of Supreme Court is there.
Yes, my lord.
Gyan Singh versus State of Punjab.
My lord, there is a judgment, my lord, reported in AIR 2021 SC 1405. Here is my lord,
Of whose court?
Honorable Apex Court, Supreme Court,
When it was pronounced.
pronounced on my lord, decided 1/3/2021.
2021.
Yes, my lord.
What is the strength of the judge? Strength of the bench? 2 judges or
Bench
3
was-
judges?
My lord, two judges.
2 judges.
Yes.
Gyan Singh is of 3 judgments.
My lord, in light of the my lord, three judges judge. Yes, my lord. My lord, in light of my lord, another judgment in Pramod Sridharan Power, my lord, this case was decided by the Honorable Apex Court. And here is mentioned that just my lord, I am relevant line I would like to read out. My lord. Bearing in mind the tests which have been enunciated in the above decision, we are of the view that even assuming that all the allegations in the FIR are correct, for the purpose of considering the application for quashing under section 482 of CRBC, now no offense has been established. There is no allegation to the effect that the promise to marry given to the second respondent was false, at the inception. On the contrary, it would appear from the contents of the FIR that there was a subsequent refusal on the part of the appellant to merit the second respondent, which gave rise to the registration of the FIR. On these facts, we are of the view that High Court was in error in declining to entertain the petition under Section 482 of CRPC on the basis that it was only the evidence at trial which would lead to a determination as to whether an offence was established. Well, this was when I held by the Honorable Apex Court.
You produced the judgment of Gyan Singh versus State of Punjab.
Some time may be granted to me. Lordship.
As read for by Mr. K. Rahman, learned counsel for the petitioner, SSL is the matter on when next week?
On
Well, after 15.
After
22nd.
15. 20?
22nd May,
22nd. Okay, 22nd.
22nd, another matter.
then 24th May,
Lordship.
24th May.
and then 22.
Your Lordship,
Hmm.
my lord, this matter relates to Jimma of vehicle, my lord.
Pardon?
Jimma of vehicle, my lord. Here you will challenge the order of the learned court below, that is on page 19, my lord. The last page, my lord. On perusal of the report, it appears that the vehicle in question is still required for holding the investigation. Where the Jimma is named
Hmm.
is rejected. My lord, the vehicle is lying in the police station for more than 3 months, my lord. And my lord, here, my lord, I have relied on decision of the Honorable Apex Court as well as the
No,
judgment
that's
of
all right, but Mr. Gogoi, whether the
Yes, that
report is
report,
available.
my lord, along with diary.
and the petitioner is not the accused here, my lord. Only his vehicle was, my lord, taken by the accused, my lord, on the request that he has got some urgent work. He is a co-villager.
No, whether this confiscation proceeding is started.
No, that is not reflect, that is not reflect. Only here I would report says that my lord, at this state not to release that vehicle, my lord, that is the report, my lord.
So the investigation is yet to be completed. As per this report.
My lord, my humble prayer is that, my lord, the vehicle may be, the Jimma of the vehicle may be given to the petitioner on some conditions that whenever it is required, he will.
No,
produce
that's
it.
all right, but unless and until the investigation is completed, how can we release the
Your
vehicle?
lordship, relevant portion, your lordship may kindly peruse at page 29, my lord. I have filed additional affidavit whereby, my lord, I have furnished, my lord, 2 judgments, my lord. This is the judgment of the Honorable Apex Court, para 17. In our view, whatever be the situation, it is of no use to keep such seized vehicle at the police station for a long period. It is for the magistrate to pass appropriate order.
No, madam,
immediate-
that's all right, but this is a case of NDPS.
But the petitioner is not the
Uh,
accused here, my lord.
Separate.
And this part is admitted. The accused is someone else. The petitioner is not the accused here, my lord. The name of the accused is Ricky Zoman Sangma, my lord.
No. As per this report, the vehicle was used for carrying these contraband substances.
Yeah, my lord, the petitioners purchased the vehicle only in the month of November 2023, my
No,
lord. And his co-villagers has taken the car only for 1 day, stating that he has got some emergency, my lord. And that is the accused, my lord, and he has committed the offense. The it was not in the knowledge of the petitioner.
Mm.
It was a new vehicle, my lord. He purchased only in the month of November, and the offense was committed in February, 13th of February, my lord.
This judgment will not help him.
Another judgment is there, my lord, of this honorable court, my lord,
Which one?
at page 33, my lord. I'm reading the third para, my lord.
Mm.
Thus, it has been summed up in the aforesaid decision that the power of section 451 of CRPC should be properly and promptly exercised so that the articles are kept for a long time in the police station, in any case, not more than 15 days to 1 month. It is for the magistrate to pass appropriate order immediately by taking appropriate bond guarantee as well as security for the return of the vehicle. In the light of the aforesaid direction of the Honorable Supreme Court, the valuable article like vehicle, etc., cannot be kept in custody of the
Maybe
investigating.
the court has relied upon the decision of this Sundar Bhai Ambala
Yes,
Desai.
my lord.
Mm.
The same should be restored to its original registered owner by obtaining appropriate bond till conclusion of the trial. So, my lord, he will
No, in that case, a trial was investigation was completed, but in the present case, investigation is going on.
My lord, with some, it may be given with some conditions that he will produce
No, no, no.
the vehicle if he
While
fails
the
to produce, my
investigation
lord.
is going on, at this it says it would not be proper to release the vehicle.
And in para 17 of the judgment, it clearly says that, my lord, this can be done pending hearing of the applications for return of such vehicles. My lord, it can be handed over, my lord, by,
No, in that case, that case was not related to NDPS.
but here, my lord, the petitioner is not the accused, my lord. It is, your lordship may kindly see the
No,
FIR
he is also being searched by police.
only because of the vehicle, my lord.
Mm. Because you are the registered owner of the vehicle,
Yes, my lord.
where a commercial quantity of heroin was recovered.
It was recovered from the accused, my lord. But the petitioner is not the accused here, my lord.
No, you are also being searched by police.
But nothing has been found in my possession. Only the vehicle is has been used. That also by someone else, my lord. Page 33, my lord. Your lordship, may I read, my lord? Considering all the entirety of the matter, the present petition is allowed. The respondent authority is directed to release the seized vehicle of the petitioner until execution of bond of rupees 20 lakhs with a direction to the petitioner that he will cooperate with the investigation.
No,
and
in
as
that
and
case,
when-
investigation was completed and search sheet was submitted.
The vehicle cannot be kept for, my lord, indefinite period of time, my lord, in the police station.
Where is the impugned order?
Last page, 19, my lord.
Heard Ms. S.B. Sodhuri, learned counsel for the petitioner. And also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. Correctness or otherwise of the order dated 12/3/2024 passed by the learned special judge NDPS Hailakandi in special within bracket NDPS case number 02 of 2024 arising out of Ramnathpur PS case number 15 of 2024 is challenged in this petition under section 482 read with section 401 397 of the Code of Criminal Procedure. It is to be noted here that by the impugned order dated so the learned special judge Hailakandi has dismissed the petition filed by the petitioner seeking custody of the vehicle bearing registration number MZ-05B 1213. Ms. Sodhuri, learned counsel for the petitioner, submits that the petitioner namely Basunga is the registered owner of a vehicle bearing registration number so and so, so and so. Or registered owner of a vehicle that is gray colored Ignis car bearing registration number so and so. The said vehicle was taken by who?
By the police of, my lord, Ramnathpur police station.
No, who had taken the vehicle from your
Vehicle
possession?
from the accused, my lord, Ricky Zoman Sangma.
One Ricky Zaman Sangma has taken the vehicle from the petitioner and thereafter said vehicle was intercepted by police on 13/2/2024 while line 2.
The said vehicle was taken by one Ricky. So,
And thereafter the vehicle was intercepted by police of Ramnathpur PS and recovered 27 numbers of plastic soap case containing 348 grams of suspected narcotic drugs within bracket heroin. Kept inside the soap cases wrapped by black colored polythene materials. Ms. Chaudhary, learned counsel for the petitioner, further submits that the petitioner is not an accused here in this case, and he is the registered owner of the vehicle, and without his knowledge, the person who has hired the vehicle carried the contraband substances, and that the petitioner will produce the vehicle before the investigating agency as and when directed, and therefore Ms. Chaudhary has contended to release the vehicle in the custody of the present petitioner. Mr. Chaudhary has also relied upon two decisions. One of Honorable Supreme Court in the case of Sundarbhai Ambala Desai versus State of Gujarat, reported in 2002 10 SCC 283, and a decision of a coordinate bench of this court in criminal petition number 384 of 2020 dated 16/9/2020. On the other hand, Mr. B.B. Gogoi, learned additional PP, has produced a report of the IO as per direction of this court dated 22/4/2024, and also the case diary before this court, and submits that the investigation of the case is still going on, and some of the accused are yet to be arrested, and as such, Mr. Gogoi contended to dismiss the petition at this stage. But having heard the submission of learned advocates of both sides, I have carefully gone to the petition and the documents plus on record, and also perused the report produced by Mr. Gogoi, learned additional PP, and also perused the case diary. It appears that the vehicle was seized in connection with Ramnathpur PS case number so and so on 13/2/2024, and the IO has recovered 27 numbers of plastic soap cases from the vehicle containing suspected narcotic drugs, heroin, weighing 348 grams. Further, it appears from the report that the investigation is still going on, and the vehicle is required for the purpose of investigation. And as such, releasing the vehicle at this stage will hamper the investigation. I have carefully gone through the decision referred by Ms. Chaudhary, learned counsel for the petitioner, and it appears that in the given facts and circumstances on the record, the ratio laid down in the aforementioned cases will not applicable in all fours. And as such, this court is inclined to dismiss this petition. Accordingly, the petition is.
That is vital, my lord. I'm relying on a Supreme Court judgment only on that point. my
No,
lord.
forget about the Supreme Court judgment. Is it the requirement of section
Yes, my lord.
306?
Yes, my lord.
Where it is stated?
My lord, look, if your lordship will kindly take this judgment, my lord, for a moment.
No. You show the section first. You read the section
Yes,
first.
yes, my lord. Lord, 306.
Hmm.
If any person
Hmm.
commits suicide, whoever abates the commission of suicide shall be punished with an imprisonment of either description of a term which may extend to 10 years and shall also be liable to fine.
Hmm.
Lord,
Hmm.
now, what is abatement, my lord?
Hmm.
The lords will find it at section.
Defined in section 107.
Yes, my lord. One zero seven. Abatement. A person abates the doing of a thing who first instigates any person to do that thing.
Hmm.
Secondly, engages with one or more other person or persons in any conspiracy for doing of that thing. If an act of illegal commission takes place in pursuance of that conspiracy and in order to the doing of that thing. Thirdly, intentionally aids
Hmm.
by any act or illegal commission the doing of a thing. Explanation: a person who by willful misrepresentation or by willful concealment of material fact which he is bound to do voluntarily
Hmm.
causes or procures to attempts or cause to procure a thing done, it is said to instigate the doing of a thing. My lord, in my case, my lord,
Hmm.
to determine whether it was the instigation, your lordship will have to consider what was the action
Hmm.
prior to the date of suicide.
Hmm. Hmm.
So therefore, my lord, I would like to take your lordship to the statements of the other witnesses also. May I, my lord?
Let us do one thing.
Yes.
Let us wait for some time. Let the court below consider the charge against you. And you argue the matter before the court below that no case is made out against you.
My lord, if you for a moment, if your lordship kindly, I want to rely on the judgment. If your lordship kindly takes.
Let the court below consider the charge first. When the next date is fixed. Yes?
No, madam. No, madam. I'm not related.
Next date to the
When the next date is fixed.
I'll have to take instruction. I'll inform your lordship.
I will inform, you inform Mr. You inform the court master
Yes.
after some time. Accordingly, we will fix the date.
Yes.
I'm sorry to Mr. Prayer at this point. Due to some personal difficulty, I have to leave early today. Item 33, bail hearing. Inform the case there is there, I'm on train. Can it be taken up on Monday or Tuesday, any date?
Okay, on the prayer being made by Mr. So-and-so, learned counsel for the accused.
Item 33.
Let's list the matter on Wednesday.
Okay.
Till then, case there will be retained.
The interim order that.
Is there any interim?
Yes.
Till next that interim order pass earlier shall continue.
Public.
My lord, as regards item number 51, your lordship wanted to know about the next date, my lord. It is on 27th of May
27th.
for consideration of charge.
So then first week of May or first week of June?
Yes, my lord. Any date by your lordship's convenience.
On 5th June.
Heard Mr. D. Usami, learned counsel for the petitioner, and Mr. Who appeared? Mr. Usami. Oh, no, so Mr. You. Mr. B.B. Gogoi, learned additional PP for the state respondent. Recessal is the matter on
5th June, 5-6.
as parted.
Deeply.
May I please, Lordship? Item number 42, my lord, as per my learned friend, my lord. He wanted to update it to case diary, my lord. Case diary received, my lord, but not up to date.
My lord, your lordship order rejection order, my lord, on 3-4, my lord. Thereafter, my lord, a case there is no update, my
42.
lord.
Mr. B. Sharma, learned additional PP, submits that he has received the case ID, but the same has not been updated since.
Since, my lord, since, my lord, 26-3, my lord.
26-3.
3.
26-3. Accordingly, it is provided that Mr. Sharma shall produce the updated case ID before this court on
On, my lord,
Request by
22, my lord.
till an interim order dated
There
25.
is no interim order.
What is this?
Item 42?
42.
This is not interim order?
No, my
Acha,
It
Ah.
it is second time, my lord.
second.
okay. Okay.
For bail hearing, item 23. My lord, in this case, my lord, search sheet file, my lord. Search sheet number, my lord, 34 of 2024, my lord, dated 30/04/24, and my lord, against my lord, Nur Alam and Inas Ali. Present petitioner, my lord, Yunus Ali.
Search sheet number,
Search sheet number, my lord, 34/2024.
under section,
Under section, my lord, my lord, 22C, my lord, and 29 NDPS.
dated
Dated, my lord, 3/04/2024.
What to do? You want to approach the trial court? Or will call for the record? You will approach the trial court. Okay. This hardness. Your good name?
Yes, sir, Kulija.
Learned counsel for the petitioner and also heard Mr. B. Sharma, learned additional PP for the state respondent. This petition under section 439 service is prepared by the accused, namely Inas Ali, alias Yunus Ali, who has been languishing in jail in connection with Nagarbera Peace case number 127 of 2023 under section 22C and 29 of the NDPS Act for grant of bail. It is to be noted here that by order dated 7/3/2024, the learned additional PP was directed to produce the case very before this court. Today, Mr. Sharma, learned additional PP, submits that he has not received the case diary, but as per his instruction, the IO has completed investigation and submitted search sheet. Being search sheet number 34 of 2024, dated 38/4/2024, under section 22C/29 of the NDPS Act. The learned counsel for the petitioner submits that the petitioner will approach the learned trial court for bail. In view of the submission of learned advocates of both sides, it is this court is inclined to dispose of this petition by directing the petitioner to approach the learned court below by filing appropriate application, and in the event of filing such an application, the learned court below shall consider the same in accordance with law.
Item 24.
Lordship, in this case, the petitioner has been languishing behind the bar for last 906 days. The case has been raised, my lord, the charges have been framed under section 21C and 29 of the NDPS.
For how many days he is behind the bar?
906 days as on date, Lordship. 906.
And this is a first application or second
No, Lordship,
application?
this is the second application before your Lordship. On last occasion, Lordship will kindly go to the order that passed by your Lordship. Lordship will find page 98, Lordship. Annexure 11. This application was filed, Lordship, when only one witness was examined before the learned trial court, Lordship.
Hmm.
And the Lordship was pleased to dispose of the bail application with a direction to expedite the trial because there was 8 listed witness, Lordship, in the case.
So till that, how many witnesses examined?
Lordship, till today, Lordship, 3 witnesses have been examined, Lordship.
Few means
3,
or 3?
3 numbers of witnesses. 3 witnesses have been examined. Lordship, the brief fact of the case is that, Lordship, on 29/3/2021, one vehicle was intercepted.
No, the thing is that merit of the case we have already considered. Now you are on delayed trial.
No, Lordship, not only on delayed trial, Lordship.
Then
Because the star witness of the case, Lordship,
Hmm.
that is one Ramesh Yadav.
Hmm.
If the Lordship kindly peruse the final complaint, Lordship will find the entire allegations by which my complicity has been shown in the case.
Hmm.
That is by way of the statement of one Ramesh Yadav.
Hmm.
He has been examined as Lordship PW2 in the case. Now, Lordship will kindly consider the statement of the PW2, Lordship.
At page number?
That has not been annexed, Lordship. Lordship, the LCR is there, Lordship. Lordship will kindly peruse from the LCR. He was examined on 13/12/2023. PW2, Ramesh Yadav.
PW?
2, Lordship. PW2, Ramesh Yadav.
Yes.
Lordship, may I read the Lordship the 6th? Today I appeared before before the court to adduce the evidence on the receipt of summons. The matter relates to March 2021. During that time, I was serving as a transport broker at Ahmedabad. On 23/2021, one mini truck UP 22T8859. This is the truck which was intercepted by the NCB officials, Lordship, was loaded and proceeded to Agartala. Ayodhya Prasad was the driver of that truck. Siam Tempo Service was in my name. I have paid the dues to Ayodhya Prasad regarding the hire of the truck. On 29/3/2021, I called Ayodhya Prasad and asked him where he has reached, and he informed that he is about to reach Guwahati. For 3 days thereafter, the phone of the Ayodhya Prasad was found switched off. Thereafter, I called Vinod Chaudhary, alias Bizarania, the petitioner before your Lordship, and asked him to look at the vehicle. The Vinod Bizarania informed me that the vehicle was caught and the Ayodhya Prasad is in jail at Guwahati. Vinod Bizarania asked me to inquire through the brother-in-law of the Ayodhya Prasad, namely Bipin. I, as a broker, provided the vehicle on being demanded by the Inter India. I asked the Bipin as to why the vehicle was intercepted by the police. Then Bipin informed me that some illegal articles might have been loaded in the truck for which the same was caught and the Ayodhya is in jail. I informed the same to Inter India. Thereafter, I again called Vinod Bizarania and asked him to take steps to release the vehicle. Then Vinod Bizarania stated to me that he did not know what was loaded in the vehicle and the steps has to be taken through court. After around 3 months, I have received a notice from NCB and I, along with one official of the Inter India, came to NCB office and gave our statement. So far, our cross part is concerned, Lordship, the clause has been declined. Because he has stated nothing against us, Lordship, and he was the only witness who has related the petitioner with the alleged offence, Lordship. Because he was the person who have stated before the NCB officials, as per the final complaint, that the person responsible for this illegal transportation of this contraband was Binod Bizarania. If your Lordship kindly
So
come,
what the complainant has deposed whether he was examined?
he is to be complainant means the seizing officer has been examined, Lordship. Seizing
Yes.
officer has been examined. He has stated nothing against us. His statement is there, Lordship. Seizing officer.
Yes, Mr. Kayan.
We have filed our objection. Let me come to page 108. Paragraph 10 and 11. Page 108 also.
Paragraph number?
Paragraph 10.
Hmm. Yes.
Contention made by the accused petitioner in paragraph 16, 17, 18. The ensuing deponent state that the involvement of the Binod Bisnaria is instant case is proved in a every angle, and sufficient documents have been submitted to prove the role of the Bisnaria. He also actual owner of the seized truck number so and so. Binod Bisnaria has not reported to NCB Guwahati office with his own after rejecting his anticipatory bail application before the Honorable Guwahati High Court. He along with the other 2 persons reported to NCB as per order of the Honorable High Court. Paragraph 11. The contention of made by the accused petitioner in paragraph 9, the deponent read to state that after charges were framed, evidence is started, but in one occasion, evidence could not be examined due to absence of the learned defense counsel for the accused Avidya Prasad. 27/3/2023 charge were framed under section 21C. 24/4/2023 PO was on leave. Then on 8/5/23 also PO was on leave. On 3/6/23 PO was on transfer. 16/36/2023. Next page. On 36/2023 witness not present. On 10/8/23 witness Chandan Das was appeared before the Honorable Session Special Court but could not be examined due to absence of the defense counsel. Then PW1 examined on 29/2023. 2 examined on 13/12/2023.
No, that's all right, but whether the complainant testified that he is the owner of the vehicle,
Yes, he is the owner of the vehicle. It is admitted.
who admitted?
That's it. He himself admitted that he is the owner of the drive. Let's we come to
Lordship has already discussed that part, Lordship, in your Lordship's earlier order. There is no doubt, Lordship, he is the owner of the vehicle, Lordship.
Achha.
We're admitting the same.
Uh.
But the Lordship fact is that, Lordship will kindly come to page 57 of our application. That is the seizure list, Lordship. The document which have been recovered from the dashboard of the truck number UP22T 8859. Page 57, Lordship. The truck was sold to that Avidya Prasad, Lordship. Accordingly, one power of attorney was executed. On the strength of that power of attorney, Lordship, the vehicle was being run by the Avidya Prasad. Lordship, first Roman 1, Lordship, Indian non-judicial stamp paper, power of the attorney given by Binod Bizarania, so and so, Avidya Prasad, driver, Dharamdal, so and so, Uttar Pradesh, with respect to the vehicle number UP22T 8859. Because the registration, transfer of the registration process was undergoing, Lordship, this power of attorney was executed. And this particular document has been seized by the NCB officials, Lordship.
Okay. Yes, any other material to show his involvement?
Lordship, these are the materials, and Lordship, I am relying on one judgment of Honorable Supreme Court regarding bail. Lordship may come to paragraph 5 to 9. That 2005. 7 SEC, page 3 to 6, paragraph 5 to 9. Where is it? Paragraph 5.
The order of the High Court shows that there are allegations of commission of offence punishable under section so and so of IPC. 6. At the juncture, it would be appropriate to take note the decision of this court in Omar Usman Chamaria versus so and so. However, before concluding, we must avert to another aspect of this case, which has caused some concern to us. In the recent past, we had several occasions to notice that the high courts, by recording the concession shown by the counsel in criminal proceeding, refrain from assigning any region even in orders which it reverts the order of the lower court. In our opinion, it is not proper if such order are applicable, be it on the ground of concession shown by the learned counsel appearing for the parties, or on ground of that assigning elaborate reasons might prejudice the future trial before the lower court. The High Court should not, unless for very good reason, desist from indicating the grounds on which their orders are based, because the matter are brought up in appeal. The courts of appeal have every reason to know the basis on which the impugn order has been made. It may be the while concerning with the lower court's order, it may not be necessary for the said appellate court to assign reason, but it is not so while reversing such order of the lower courts. It may be convenient for the said courts to pass order without indicating the grounds or basis, but it's certainly not convenient for the courts of appeal while considering the correctness of such impugn orders. The reason need not be very detailed or elaborate, and lest it may cause prejudice to the case of the parties, but must be sufficiently indicate the process of reasoning leading the passing of the impugn order. The need for delivering a reason order is requirement of law, but which has to be complied with in all applicable orders. This court in some part similar situation has deprecated the practice of non-speaking order in case of state of Punjab and so on. And paragraph 7. This aspect is recently highlighted.
How this observation will help you?
No, Lordship, subsequent paragraphs. And on cursory perusal of the High Court's order shows complete non-application of mine. Though, Lordship, here the London trial court has rejected the well application of the petitioner. Then in every cursory, though that decision, the detailed examination of the evidence.
No, the ground he assigned for filing this petition is that till that 4 witnesses have been examined and none of them has
That is my point, Lordship.
have whispered any word.
In paragraph 8, even on cursory perusal of the High Court's order shows complete non-application of mine. Though detailed examination of evidence and elaborate documentation of merits of the case is to be avoided by the court while passing the order on bail application. Yet a court dealing with the bail application should be satisfied as to whether there is a prima facie case, but exhaustive exploration of merit, the case is not necessary. The court dealing with the application for bail is required to exercise its discretion in judicious manner and not in a matter of course. Next paragraph. There is need to indicate the orders reason for prima facie concluding while bail was being granted, particularly where a accused was charged of having committed a serious offense. It is necessary for the courts dealing with the application for bail to consider, among other circumstances, the following factors to be also before granting bail. They are: 1, the nature of execution and severity of punishment in case of conviction and the nature of supporting evidence. 2, reasonable apprehension of tampering witnesses or apprehension of threat to complainant. 3, prima facie satisfaction of the court in support of the charges. Paragraph 9 and 9 mainly underlined.
No, these are the all parameters laid down by Honorable Supreme Court in several other
Yes.
cases.
And regarding Lordship.
Nothing new.
Not that. Yes,
But you saw where is the evidence against him? My question is that
no, Lordship, my humble submission at this stage, whether Lordship will appreciate the evidences.
no prima facie.
Prima facie, Lordship, prima facie.
Yes, prima facie.
Facie case is there charge in frame against him.
So if your star witness has not whispered any word against him, then how can you
Now, Lordship, may come
keep
to
him
page
behind the bar?
103
103 of
of the bail application. Right, order dated 1st of April 2024, passed by the learned special judge.
103.
Lordship.
Yes.
Lordship may come to page 105. Paragraph, second paragraph.
Hmm.
Record reflects that in case the charge was framed on 27/3/2023 and till date evidence of two PWs were examined and cross-examined and PW3 was examined in chief on 5/3/2024 and his further examination in chief is reserved. Record also reflect that the accused person in jail since 17/11/2021 and as such accused persons has not qualified the period as described in Satyendra Prasad until case.
Hmm.
After taking into consideration all these above facts, I am of the view that the regards of section 37 of the NTPS Act is applicable in the respect of accused Vinod Biznaria. And at this stage, it is not possible for this trial court to come to satisfaction that the accused person is not guilty of the offence and he is not likely to commit the offence if allowed to go on bail. After taking into
So
consideration-
where is the prima facie material to show that he is not guilty or he is guilty of the offence?
Lordship may come to page then supplement complaint file after he is arrested.
No, we are not concerned with that supplementary complaint. We are concerned with the evidence so brought on record before the trial court.
Out of 8 witnesses, 3 witnesses been examined.
Hmm.
This 5 has to be examined. IU has to be examined. What materials will be placed? At this stage, I cannot say lot. And whether Lordship has some Supreme Court has stated that while granting the bail, the merit of the case should not be considered. Lordship, all the evidence should be meticulously.
What to be considered that?
Lordship, if the private, Lordship, here in this case,
Hmm.
the matter is relating to involvement of the narcotic drugs also. This is an heinous offence. And Lordship, prima facie charge has been framed by the learned trial court after going through the materials on the record.
Hmm.
Now evidence is going.
No, that stage is over. Now the witnesses, 4 witnesses have been examined.
Only
If none of the witnesses whispered any word against the present petitioner,
Lordship,
how can you say that prima facie case is made out?
Lordship, when charge has been framed, Lordship,
Hmm.
if the other witnesses fail to adduce against him, then he is entitled to acquittal, Lordship.
Hmm.
But Lordship, whether we
No,
can-
entitled to acquittal, that's all right. But if you take another 20 years to complete the trial, then
No, Lordship, in case of NDPS,
Hmm.
as stated in the Satyendra Prasad until case,
Hmm.
earlier Lordship 436 capital was not applicable,
Hmm.
but thereafter it was made applicable.
Hmm.
And 436 says that the maximum punishment to be
Hmm.
calculated.
Hmm.
So here maximum punishment is 20 years.
Hmm.
Then he doesn't fall under section 436 also.
Hmm.
And he was arrested on 17/11 probably.
Hmm.
17/11 2022.
Hmm.
21.
Hmm.
2 years, only 2 years has been completed. So he's not qualified to be entitled to.
That's all right. But if no prima facie case is made out, then
No, Lordship, regarding prima facie case, when charge has been framed, whether we can come to a
no,
conclusion.
that's all right. But that stage is over. Charge has
No,
already
Lordship.
been framed. Witnesses examined. Then
out
where
of-
is the material to show the prima facie case?
Lordship, at this stage, I can assist your Lordship by pointing out the materials collected during the investigation. And the out of 8 witness, admittedly 4 has been examined, rest is to be examined.
Hmm.
IO is to be examined.
Hmm.
What materials he will place?
Hmm.
At this stage, I cannot say. Lordship.
No, what materials is to be placed? That is already in the complaint.
Look, that is there, Lordship.
Yes.
After going through the complaint, there is a sufficient materials. That's
Ah.
why charge has been framed. Lordship.
So according to him, the star witness is PW2. PW2 has not
So far-
whispered any
so far
word
my case
against
is
him.
concerned. So far, my case is concerned,
Huh.
PW2 is the star witness because he is the person who has implicated me with the case, Lordship. Because as per his statement, which
Hmm.
have been given before the NCB,
Hmm.
which have been mentioned in the final complaint, Lordship,
Hmm.
he has implicated me that I was aware regarding the loading of the contraband in the vehicle,
Hmm.
and I was responsible person with the transportation of that contraband to the Agartala,
Hmm.
Lordship.
Hmm.
He has stated, and that has been reflected in the final complaint.
Hmm.
But before the court, Lordship, he has deposed in a different way. So apart from that, Lordship, if Lordship kindly come to page 50, Lordship.
Yes.
and Page 50, the list of witnesses, Lordship. Lordship will find the first witness is Rakesh Kumar Shukla. He is the director, Lordship. He is the zonal director.
Mm,
So his part is only regarding search and seizure.
Hmm.
Now, PW1, Sondon Das, he has been already examined. He is the scientific officer, Lordship.
mm,
PW3 is the superintendent of Narcotic Control Bureau, Guwahati.
mm,
PW4 is the Onil Kuswa, IO,
mm,
intelligence officer, NCB seizing officer. His evidence has been completed, Lordship.
Mm.
PW1, Sondon Das has been completed.
Mm.
PW5 is the Kaushik Sarkar. He is the investigating officer.
mm,
PW6 and 7, they are the independent seizure witnesses, Lordship. So I have nothing to do with the seizure because nothing has been seized from my possession.
mm,
From the truck that was intercepted, the article was seized. Only
Mm.
my complicity that has been shown by the NCB, Lordship. Lordship will find that is the 67 statement, confessional statement, Lordship.
mm,
CDR and the statement of the Ramesh Yadav, who has implicated me with the case, Lordship.
mm.
So far my case is concerned, he was the star witness, Lordship. Now, apart from them, these are the official witnesses. There is no scope.
Yes, sir. Rakesh Kumar Jadhav,
Ramesh Kumar Yadav,
Kumar
Lordship.
Ramesh Kumar Jadhav.
PW2. He has been examined as a PW2, Lordship.
Mm,
The final complaint, if you kindly, Lordship, kindly goes to the final complaint, Lordship will find that only this person has stated and implicated me with the case. Apart from him, only CDR and a 67 statement is there.
Yes, Mr. Kayan,
Lordship.
67 is not applicable.
Yes, 67 is not applicable.
Mm.
That is, Lordship, there is no.
Then do you think that the examination of this IO will improve your case then?
That, at this I cannot say, Lordship. Maybe,
Mm,
maybe, Lordship.
mm. How, what he will depose? Everything is already on record.
No, Lordship, the submission made by my learned friend that the entire case is based on the statement of PW2.
Mm.
Hopefully, Lordship, that doesn't hold any water.
Not,
Because unless all the main witnesses examined, Lordship, what materials will come? At this stage, Lordship, it will be difficult for me to.
no, as submitted by him. This witness number 6 and 7, they are Caesar witness.
Yes, Lordship, now,
So as nothing has been recovered from his position.
no, regarding Lordship IO, because he is the main witness,
Mm.
what materials he will place?
Materials are already there, Lordship, in the report. He
No,
cannot-
he cannot bring more materials on record.
He has already
Already
submitted
it
the
is
final
on the
complaint.
record.
Definitely, Lordship. I cannot submit beyond the record,
Mm,
but regarding the nature of the case
mm,
and the law laid down by the rules of Supreme Court on the basis, I can assist your Lordship.
mm,
And Lordship, furthermore, his bail application was rejected twice. First
mm.
by this honorable court, by the learned special court also. Lordship.
There is no concealment, Lordship. Everything has been placed before your Lordship.
I am not said that he has.
There is no concealment.
What my learned friend is submitting, Lordship.
Let him complete.
Whether I have made any submission that he has suppressed many materials.
Mm.
Page 103 is clear. The three-page order. Every aspect of the matter has been considered by the learned special court.
Mm.
And moreover, Lordship, this order has not been challenged. This order has not been challenged.
No, in order to file a petition before the High Court,
Yes, Lordship.
this challenge of this order is not required.
Yes, Lordship. This is my point. He can file as many as bail application,
Mm,
but when that learned trial court has
mm,
rejected his bail on 1st of April 2024
mm,
by citing some reason and on the basis of the record.
mm.
In his main ground that witness has not submitted against him. Only this is the main ground. Let me please see to his prayer also. Simple query for seeking bail also. There is to seeking bail only.
Mm,
He has not challenged this order also.
mm,
So Lordship, when the learned trial court, after perusal of the record, come to a conclusion that he is not entitled to bail,
mm.
it is not incompetent for him to challenge this order, Lordship.
No, it is not necessary. He can file under section 439 CRPC. Option is available to him. He may file it before the trial court and also before the high court.
The Lordship, when this bail application was rejected by a reasoned order, will not be Lordship to consider all these things that we say, when see bail application is considered.
No, there is sense of circumstance thereafter. After examination of 4 witnesses, no
Lordship,
prima facie case is made out according to him. I have not checked the record.
Lordship, that has been considered by the learned trial court also.
Hmm.
In paragraph page 105.
Hmm.
Again, I am placing that paragraph. Record reflects that in case the charge was framed on 27/3/2023 and still date, evidence of 2 PWs were examined. At that time, Lordship, PW2 was examined. Were examined and cross-examined, and PW3 were examined in chief on 5/3/2024. And his further examination in chief is reserved. Record also reflects that the accused person is jail since so and so, and as such, the accused person has not.
No, that is admitted that he has not completed the required years
Lordship, my
as
point,
prescribed in the case of Satinder Antel.
Lordship, my point, I'm placing the point before Lordship. My learned friend has submitted the PW2 examine and he has said nothing against him. That was considered by the learned trial court.
No, thereafter also 2 more witnesses have been examined.
One seizing officer.
Seizing officer.
Seizing officer.
Because nothing was seized, so there is not, that is not in relation to petitioner also.
Then examination of the IO, how you will improve your case?
Lordship, that at this stage, Lordship, how can make any comment?
Unless and until something miracle happened.
That's Lordship, I cannot make any comment at this. I cannot make any comment. And regarding Lordship, delayed trial, Lordship. Allahabad High Court.
No, he is not on that ground. He is on the ground of the
So,
absence of
Lordship,
prima facie case.
Only on prima facie.
Okay, anyway, I heard Mr.
2005
Peters, learned counsel for the
That will be
petitioner,
considered.
and Mr. Kayal, learned standing.
Please, Your Lordship. The CD was called for.
The CD receipt. Petitioner is in interim, my lord, and they have interim, no interim, but 41 notice was served on him, my lord. He appeared.
Statements.
41 in notice was served, my lord. He appeared, my lord. His statement recorded. Investigation is going on. This is case of my lord 2016 case. It is related to APSC the appointment.
My lord was pleased to consider similar matters, my lord. Some orders, if my lord may like to peruse.
So his custodial interrogation is not required.
My lord, once he appeared, not arrested, my lord, his statement recorded.
Heard Mr.
Similar.
P.D. Nair, learned counsel for the applicant, and Mr. B.B. Gogoi, learned additional BP for the state respondent. Apprehending arrest in connection with Digubur PS case number 936 of 2016 under section 7, 13(1)(a), B, D, within bracket 2 of the Prevention of Corruption Act, read section 120B, 420, IPC, edit section 463, 468, 471, 477, capital A, 201 IPC. This application under section 438 services prepared by applicant on John Jyoti Das for grant of previous pay. It's to be noted here that above noted case has been registered on the basis of one FIR lodged by one
Anshumita Gogoi.
Anshumita Gogoi on
By the 27/10/2016. Page 23, my lord.
On 26, on 27/10/2016. The sense of allegation made in the FIR dated so and so is that one Nabakanta Pate of Dibrugarh contracted her and asked her to pay about rupees 10 lakhs for the purpose of recruiting her to the post of dental surgeon, to be conducted by the APSC. Also, when the informant along with her friend Arup Barkotoki came to his residence in Dibrugarh, the police personnel of Dibrugarh PS apprehended Nabakanta Pate from his residential premises located at Circuit House Road near Damanis Nursing Home, where he was receiving the demanded money. The allegation against the present applicant is that where it is mentioned his allegation.
My lord, in the charge sheet, my lord, in the departmental proceedings, that, my lord, page 49, my lord. Sorry, my lord. Sorry. Page 36. my lord. Sorry. Sorry, man, page 34. 34, I apologize, my lord. Enhancement of his marks in the final tabulation sheet. Second
Please.
paragraph. Page 34, my lord. Second paragraph.
He is the beneficiary of the anomalies and malpractices carried out by the APSA, and he got recommended by the APSA for appointment by enhancement of his originally scored mark in the final tabulation sheet, based on which the final result were declared. Mr. Nair, learned counsel for the applicant, submits that the applicant is innocent and no way involved with the offense alleged in the FIR. And he has received notice under section 41 ACRPC and appeared before the IO. And his statement is also recorded. And that some of the co-accused have already been enlarged on bail by this court in AB number 68 of 2024 by order dated 16/2/2024, and in AB number 62 of 2023
416.
by order dated 28/2/2024, and that the present applicant is also stand in the same footing with the applicants of those AB, and that he is ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. On the other hand, Mr. B.B. Gogoi, learned additional PP, has produced the case before this court and submits that investigation completed.
Investigation not complete, further investigation is doing, my lord. But once 41A notice
Submits
issued,
that,
accordingly he appeared.
Further investigation of the cases is still going on, but the applicant, pursuant to notice under section 41 ACRPC issued by the IO, appeared before the IO, and his statement is recorded, and he has been cooperating with the investigating agency. Having heard the submission of learned advocates of both sides, I have carefully gone to the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Gogoi, learned additional PP. It appears that the applicant has received notice from the IO concerned and appeared before the IO, and his statement is also recorded. Further, it appears from the case diary that The IO has achieved substantial progress in the investigation of the case. So far, the present applicant is concerned, and that some of the co-accused have already been granted the privilege of appearance by this court in AB number so and so so and so. But having considered above, and also considering the materials available in the case area, and also in view of the cooperation being extended by the applicant to the investigating agency, his custodial interrogation seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant in connection with Dibrugarh PS case number so and so under section so and so, he shall be released on arrears bail on his executing a bond of rupees 50,000 which once you like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition, he shall not leave the jurisdiction of CJM Dibrugarh.
Now it's under special judge Guwahati, my lord.
Special-
State of Assam, my lord. I'm a resident of
Oh,
Guwahati.
shall not leave the jurisdiction of special judge Guwahati without prior permission.
Deeply
In
offensive.
terms of about this evidence, disposal of CDB returned.
Item 38. My lord, the second bail application number, my lord, is 4162, my lord. Okay. In the order, my lord, sir. Deeply offensive.
My pleasure, Lord.
38.
I think it was called for, we are on interim lordship.
Pardon?
We are on interim lordship. We had appeared before the IO lordship.
My lord, CD received, my lord. After interim, they have appeared before the IO, my lord, statement recorded, but some materials are there against the, my lord.
No, if they are cooperating with
My-
you, cooperating with the investigating agency,
My lord.
whether their custodial interrogation is required.
No, my lord, that is not reflected here, my lord. But from their statement itself, they said that my lord, they have prepared the full documents, my lord, not for prepared, my lord, they have applied for birth certificate, my lord. Although there is the original birth certificate of the my lord.
So the,
Accused person, my lord.
we are not the FIR accused lordship. The accused in the FIR lordship, she was rescued from in the year 2017. Thereafter, she was sent to the home lordship. There is child care home lordship.
Where is the FIR?
FIR page number 15 lordship.
Oh, what is the allegation?
Allegation regarding the one birth certificate, false birth certificate with regard to the accused lordship. So what happened, lordship? The accused was rescued in the year 2017, lordship.
No,
We
who
are
is
the-
the accused?
We are the not accused, lordship.
Not in another case, my lord. In the case of the accused, my lord. Rimika Tanti, my lord. She was the accused of another case, my lord. CR case number in the court of 216, my lord. But here she has submitted one birth certificate, my lord, in which it was shown that she was minor, my lord. That's why order was passed as she is juvenile, my lord. Then what happened, my lord? After that, it was inquired and RTA information was taken, my lord. Then it was submitted. It was found that
No, what is the allegation against the present
my lord,
applicant?
against the present, my lord. They are the director, managing director of CWC, my lord. Where's
Whom? We are the managing director of whom, namely
Seven Sisters home, my lord. They are the here the accused person was here in the my lord, Seven Sister home, my lord. And from the statement it reveals that, my lord, here they have applied for the from here they have applied for the, my lord, birth certificate, my lord.
What happened, lordship?
Birth certificate of?
The accused person, that accused person, my lord. Who is
Who
found
is
to
the
be
accused person?
found to be fake, my lord. Really?
Rimika Tati, lordship.
Rimika Tanti.
So what happened in the year 2017, lordship, the accused Rimika Tati was rescued from under the jurisdiction of Dispur PS, lordship. Thereafter,
Rimika Tanti.
thereafter she was referred to the child care home, lordship, that is Seven Sister home, where the petitioner number 1 and 2 are the managing director and deputy managing director, lordship. Thereafter, on the request of CWC and the other person, lordship, we have applied on birth certificate, Lordship, where the address was mentioned as Seven Sister Home, Lordship. That for which in the FIR, the accused name and address was mentioned as Seven Sister Home, Lordship. We are not named in the FIR, Lordship. Thereafter, the IO has telephonally informed us, and we have appeared. We have appeared before the filing the anticipated bail, Lordship. Thereafter, again, the IO has called, Lordship.
No, the accused
Lordship.
Rimika Tati was lodged in your home,
Home, Lordship.
My lord,
of which you were the director.
Yes,
director.
And thereafter, as per direction of CWC, you have applied for birth certificate of the
Birth certificate.
birth certificate of Rimika Tati,
Tanti, my lord.
and you have applied for the birth certificate.
My lord, my lord. That found fact. That birth certificate found to be fact.
No, who had issued that certificate?
That was a report, my lord, from health.
But
I
not
beg my lord, report, my lord. Here
Hmm.
report was found, my lord.
Registered birth and death,
My lord,
Joint Director of Health Services, Kamrup.
my lord. And
You
her
know, why you were apprehending arrest then?
Lordship, in the FIR, the address name is shown Seven Sister Home, Lordship. And Lordship, we had appeared before the filing the bail application, Lordship. Thereafter, again, the IO has called, Lordship, to
Okay. Heard, Mr.
B. Bormohai, Lordship.
Learned counsel for the applicant, and also heard Mr. B. Sharma, learned additional PP for the state respondent. Apprehending arrest in connection with Mongoldoy PS case number 44 of 2019 under section 193, 468, 471 IPC. This application under section 438 services preferred by three applicants, namely Perdictor Rampipo, Anna Eni,
Barla.
and Pratima Lakra for grant of PRS bail. The aforementioned case has been registered on the basis of one FIR lodged by one Anil Sanda Sharma, principal. No, retired Professor Mongoldoy College on 19/1/2019. The essence of allegation made in the FIR dated so and so is that one Rimika Tati has submitted one false date of birth certificate in criminal case number 216 of 2017. The learned counsel for the applicant submits that the applicants are granted the privilege of interim PRS bail by order dated 8/4/2024. And thereafter they have appeared before the IO and their statements have also been recorded. And that they are no way involved with the offense alleged in the FIR. And they are ready to cooperate with the investigating agency. And therefore, it is contended to make the interim order dated 8/4/2024 absolute in the same terms and conditions. On the other hand, Mr. B. Sharma, learned additional PP, has produced the case before this court and submits that the IO has collected some materials against the present applicants. But Mr. Sharma submits that Mr. Sharma also submits that the applicants have appeared before the IO and their statements have been recorded. But having heard the submission that line, the case diary indicates that the IO has collected some materials in support of the allegation made in the FIR. But it also appears from the case diary that the applicants have been cooperating with the investigating agency and They have appeared before the IO and their statements have also been recorded. In view of above and also in view of the progress of investigation, custodial interrogation of the present applicant seems to be not warranted here in this case, and therefore this court is inclined to dispose. This court is inclined to make the interim order dated 8/4/2024 absolute in the same terms and conditions. Is there any
Lordship, Miss Vivi Thani, Valentina Villabino Thani.
learned counsel for the respondent opposite party? This interlocutory application is preferred under section 256 of the Code of Criminal Procedure for substitution of late Ram Avatar Jalan, proprietor of Assam Supply Syndicate, by his authorized heirs, namely Sri Siraj Jalan, in criminal revision petition number 224 of 2015. Ms. So-and-so, learned counsel for the opposite party, submits that she will file objection here in this petition and price for granting her some fine. There is accordingly allowed. Rest is the matter on when
Lordship, after 2 weeks.
2 weeks.
Yes, my lord.
But date
No, this is a 2015 matter.
15 might have, because they've already paid 48 lakhs. Because there was a compromise deed, my lord. They had paid 48 lakhs out of 62 lakhs and plus interest is there. So now they want to file a technical problem. That's okay, my lord, because under 256, the legal years has to be completed. So let it be a date may be fixed.
Suggest the date.
You suggest the date? 3rd June. 3rd June.
Lordship, can it be on the 2nd week of June, any date?
Pardon?
2nd week of June, or 3rd week of June?
3rd week of June. 3rd week of June. You want 2 weeks then? So how is 3rd June?
Any date, my lord.
The 3rd June.
I have to obtain instructions, my lord, and talk to the bank as well. Much obliged.
I take apology, Lordship. In item number 55, Lordship, there is an interim order, Lordship, that may be.
Already ordered.
Lordship, obliged, Lordship.
My lord, this matter has been heard by this honorable court.
Yes.
And lordship, as because there was a service has not been, I mean to say notice has not been served on respondent to. The lordship has directed the petitioner to again serve the notice upon the respondent number 2. It has been served, lordship.
Lordship, we have filed the trustee service affidavit on 2nd of May, your lordship. That begins with page number 1057. Page 1060 may be perused, your lordship. Annexure A.
Okay, the original document, original case.
Also, your lordship, as lordship had indicated, your lordship, we had inquired from the postal department, your lordship. So, your lordship, this document, the consignment of our petition was delivered on 8/8/2023. And there is a signature also, lordship would kindly, lordship would like.
No, but you could have made part of the affidavit also here.
This-
That document.
This document I received later by post, your lordship. The postal department submitted later I already filed the dusty service affidavit. Afterwards, I received this document, so I could not annex it, Your Lordship. Bottom page, Your Lordship, 8/8/2023. There is a sign also. This has been forwarded by the postal department. The seal is on top of the page, Your Lordship. It came by post, so I couldn't annex it. Your Lordship.
So bring it on record by filing an affidavit.
This document. Your
Yes, yes.
Lordship, just out of the record, Lordship, this informant, he came to the office of the CBI also after receiving this notice.
Yes.
So it is not on record because I cannot put it on record. However, Lordship, over phone, Lordship, I had a talk. I told him that I am arguing. And I also suggest him to appoint any other lawyer because the notice says you cannot appear personally, you have to engage a lawyer. So he said, no, CBI will have to argue. So I said, I am arguing. Even then, if you want to appoint any lawyer, you are at the liberty to appoint lawyers. And if you have no money, then we can engage the amicus curiae also from the legal aid cell also. That those things has been told to him. But he is adamant that CBI will have to argue. I'm arguing. I've already put my, already submitted my argument. That was what he.
When was this?
Okay, we'll file a, oh no, we'll list the matter after 1 week or 2 weeks. Whatever convenient to you.
Lordship, I'll file an affidavit bringing about this postal department information. Yes. Lordship is fixing that date. Your Lordship.
Yes, we will fix a date.
Not date. Your Lordship.
Third, Ms. N. Bordola, learned counsel for the petitioner, and Mr. M. Halloway, learned PP for the special PP for the respondent CBI. Office note dated 8/5/2024 indicates that an affidavit regarding dusty service of notice upon the respondent number 2 has been placed on record. As a result of the same regals that notice upon the respondent number 2 was served by Dusty Mode on
34/2020.
on 30/4/2024 by obtaining signature of the petitioner in the copy of notice. Further, Ms. Bordola submits that she has also received one report from the postal department in respect of delivery of notice to the petitioner, respondent number 2. And she will file an affidavit to that effect, bringing on record the aforesaid document. Accordingly, it is provided that Leicester list the matter on sorted.
15th of May, Your Lordship, if I may.
15th.
1/5. I just have to file.
No, maybe, but in the meantime, he may, the respondent may engage the advocate also.
But
As per Learned Counsel's
I cannot say
submission
on behalf of the respondents, not my duty. I'm appearing on behalf of state of
of the record.
central lordship, CBI lordship. So for CBI, I've already made my argument. I've already put my argument. So if the respondent, from the mouth of the respondent, I heard lordship, I helped him. You can engage the amicus curiae also, legal aid counsel, so you can no money. I will help you out. He is stating that no, you have to argue. I have already argued. So that is the situation. Lordship. So, you want
let us fix on 20th.
28 lordship.
20.
Yes, yes.
20. So as to enable Ms. Bordola to bring on record documents she has received from the postal department.
Obliged, Your Lordship.